It is my pleasure to introduce the next session on abuse of dominance in the digital age. So a lot has happened recently on the application of Article 102, and in particular in digital and tech. We've heard today from Commissioner Ribera that there was a new case regarding Google AI overviews. The 102 exclusionary guidelines are expected soon. And as you probably all know, they have sparked a lot of commentary. But meanwhile, cases continued. And in Europe, regulators have been grappling with difficult questions of unfair trading conditions, unfair competitive advantages, tying, self-referencing, including in cases like Google AdTech, Microsoft Teams, Facebook Marketplace, the Apple dating apps case, for which the ACM's decision has been upheld earlier this year. And the EC also launched last week, I think, an investigation in Meta AI WhatsApp, which is complementing the Italian and Brazilian proceedings on a similar case. Now, if we look on the other side of the pond, so in the US, also major decisions this year, Google Search, Google AdTech. Last month, the FTC Meta decision. So there is a lot to unpack, and we will focus on a couple of specific themes for this session to shed light on the evolution of Article 102. And we just heard something along the lines that we were entering perhaps in a new ethical era. So is it related also to what we are seeing in Article 102, the economics of digital platforms, and whether AI is a game changer? We've seen that in some recent judgments, and if so, how? So as you can tell, we have an ambitious program. Luckily for me, I don't have to do anything. I have with me fantastic speakers that I'm going to turn to that are up to the task with a combination of top regulators and top academics. So starting with Pinar Akman, she's a professor of law at the University of Leeds. Outside of academia, she recently joined White & Case as a senior advisor and has served as a judge at the UK Competition Appeal Tribunal. She's been profiled as one of the world's most influential competition scholars by GCR, and I'll spare you the long list of publications she has on topics relevant to our discussion today. Next is Leonardo Bursztyn. Leo is the Saieh Family Professor of Economics at the University of Chicago. He's a globally renowned economist, and he's studying he's at the intersection of how individuals' economic decisions are shaped by their social environment. So a bit of a different perspective that will be interesting to hear from today, and how this has implications for firm strategies and market power. Next, Michael Jacobides. Michael is a Sir Donald Gordon Professor of Entrepreneurship of Innovation and a Professor of Strategy at LSE, London Business Schools. And he's regarded as one of the finest minds in entrepreneurship and management globally. On the regulator side, we are extremely pleased to have with us Lindsay McCullum, Acting Director General at DG Comp and Deputy Director General for Antitrust and Regulation of Digital Platforms, and Martijn Snoep, the Chairman of the Netherlands Authority for Consumers and Markets. So let's dive in. And I will start with you, Lindsay. Against the backdrop of recent 102 cases, there have been many, as I just mentioned, and also recent DMA decisions, how do you see the evolution of Article 102 or the application of Article 102, and also how do you see the interplay with the DMA?
Well, thank you very much. It's a pleasure to be here. I'm going to start with what I think of as some good news, which I think is that there really is international consensus that we need to intervene against unilateral conduct in digital markets. And as somebody whose memory stretches back some way, that is not a given. I remember many conferences where we discussed that these markets were just too complicated for unilateral conduct to get involved, where there was no harm, because where was the price issue, where they would self-correct. So I think it's worth pausing for a moment, comparing and contrasting and seeing where we are with so much happening in so many jurisdictions around the world, also on the other side of the Atlantic, dealing with very similar issues where the harm which we're essentially concerned about is not price, may not be price at all, maybe quality, maybe choice, maybe innovation. And that's the trend that you see reflected in our draft 102 guidelines, and I think it's worth noting. I think the second thing I would say from a Commission perspective, and here I'm just talking about 102 for the moment, is really that we've kept this instrument relevant because we've been willing to make sure that our enforcement is adapted to the specificities of digital markets. So yes, we've had some, plain vanilla classic tying theory of harm cases on the exclusionary front. Recently, Teams, the tie with Microsoft's productivity software, or the classified ads tie to Meta's social network. But we've wanted to, and we have adapted in those cases to what's specific about digital markets, so full effects analysis. And we've also been willing, and I think that's been important, to keep pushing the boundaries of types of theories of harm on unilateral conduct, which is what you've seen with self-preferencing. We're coming up to the 10-year anniversary of the Google shopping decision, now upheld at second instance. Certainly not at the time the subject of universal acclaim from the economic community. And I think it's precisely because we've been active enforcers on the exclusionary abuse front that trying to codify that in guidelines made sense. And we're within touching distance, not for Christmas, but in the new year of bringing that process to a close. What you've seen recently is a bit of a pivot on our side away from cases purely focused on exclusion towards cases that have a more exploitative favor. We're going to dive into that in more detail, but I do want to address it because I think for us, these cases which are about the imposition of unfair trading terms causing direct consumer harm have been an important way to engage with what we see as the reality of some of these digital markets. Because if you do look at, app stores, or if you look at online marketplaces, if you look at these important infrastructures that are operated by dominant players, you see that their incentives can be very mixed. Because they want, on the one hand, to have lots of intermediation and business users using their platform, because that's what makes it interesting for consumers. And on the other hand, they're competing with those business users. So the temptation to, how can I put it, dimension that competitive thread is pretty strong. So that mixed incentive is what we've seen play out in a couple of our decisions, specifically the Apple Music streaming case, in terms of the impact of the prohibitions on the provision of information to consumers in terms of prices. And then also, of course, in Facebook Marketplace, in terms of the use of data by competing providers of classified ads with Meta through the data that's provided because they're advertising on the platform. Today, of course, I think one of our principal concerns still on 102 when it comes to enforcement is to think about what are the types of conduct that we want to intervene on with a view to artificial intelligence, with a view to the way in which those markets will develop. And that's essentially the explanation for why you saw us open a case last week in terms of Meta's cutting off of access of competing AI chatbots to WhatsApp. We were very happy to cooperate on that with the AGCM in Italy. I think if we leave substance behind for a moment and look at procedures, I think that will be an interesting natural experiment for us, also when we're looking at Regulation 1 in terms of who has a good framework for interim measures. If that case proves to be worthy of interim measures, and of course we're only at the opening stage. And then today, in terms of AI, we've opened a case which also has an exploitative and exclusionary angle in terms of Google's, the terms and conditions that Google is imposing on publishers, but more broadly on content creators in terms of the use of their data by Google. So I think the good news is that this is an evergreen topic of conversation. It is important to continue to enforce against unilateral conduct in this space. The Digital Markets Act. The Digital Markets Act, in terms of its interplay with 102, on the one hand, I think is really straightforward. These are complements, these are not substitutes, to use your lingo. That is reflected in the legal texts in Article 1.6, which states very clearly on its face that it's without prejudice to the application of Article 102 in particular. But what you see, of course, is that the DMA is not a text that applies across the board in digital markets. It's specific designated gatekeepers in respect of specific services and specific conduct. And that means that there's a lot of room left for the enforcement of 102 in these markets. And I think you just have to look at some of our recent decisions to understand the extent to which that's true. Look at Google Ad Tech. Yes, a designated gatekeeper. Yes, we have therefore designated core platform services. But the conduct at issue in terms of self-preferencing in the ad stack is not caught by the DMA. Or think about Teams, the Teams case. Yes, Microsoft a designated gatekeeper, but neither the tying product, the productivity software, nor the tied product subject to the DMA. And that is also the case for the cases we've just opened, really not falling squarely within the DMA's ambit. So I think in general terms, in terms of how these legal instruments interact, they will proceed in parallel. They will have their own lives. I think there is a lot to be said for the proposition that where you're looking at new conduct in new markets, where you really need to have gone through the full-blown assessment for which antitrust law is so well suited, that's where you need 102. Whereas the DMA is dealing with conduct which has been subject to much of that assessment in the past, and where we're therefore coming out in favor of a more regulatory ex-ante approach. But of course in life these things are never quite as simple, which is why on the DMA front with cloud we've opened not just qualitative designations in respect of Microsoft and its cloud offering, and in respect of Amazon and its cloud offering, but we also wanted to open a market investigation so we could have a look at the substantive obligations in the DMA and see whether those are really fit for purpose for these markets, which, I think are pretty important for Europe's competitive future. And if ever there was a time when a discussion round about resilience and open strategic autonomy seemed quite timely, it's probably now.
Very good. Thank you very much. So I'd like to explore one theme in particular a bit more, which is that also building on what you just said and the previous panel, this idea that we are moving to new ethical era potentially. So many cases, I think it's fair to say, seem to move away from foreclosure and a bit more towards a notion of fairness. Unfair trading conditions, unfair competitive advantages. But as you can imagine, as economists, we're a bit, what is fair, what is unfair? How do we deal with these questions? And so, and also, is fair and fairness the sort of upcoming 102 theory of harm? So, Martijn, starting with you, and then Pinar, if you can share your observations after. I know you don't necessarily share the same views, so that's going to make for an interesting discussion.
All right, I'll take up the challenge. Thank you very much. No, and I really think and appreciate the fact that you're organizing this panel around this topic, because it is an important topic, and it is a topic that's close to the heart of my agency and also myself personally. I think if we take a step back, their competition law has a clear function as a sword. And it is as a sword, it aims to protect and restore competition that was harmed, or that is about to be harmed. And that's for merger control, that's for cartel prohibitions, for exclusionary conduct prohibition. But we shouldn't forget that competition law has also a function as a shield to protect people and businesses against unfair conduct by a dominant company. And that's, of course, the prohibition for the exploitative conduct. And unfortunately, competition law as a shield was neglected for a few decades. And it was, I think Lindsay said that at a conference not long ago, it was a little bit the unloved child of competition law. But the good news is that child is becoming loved again. And you see this not only with the Commission, but also with the national competition authorities. And the aim of these exploitative abuse cases is not to prevent or restore competition that was harmed, but really to protect people and businesses against exploitative conduct. So the goal is not to mimic and to force the dominant company to behave as if there were competition. You know, think about, for example, excessive prices. We do not say that every price above the competitive level is an exploitation, is a prohibited price. So we say there is a price that can be unfair, and whether it's a price or a condition, it depends on the circumstances. And I understand the difficulty with that. It's not always predictable what exactly the norm is, and therefore not every case may be appropriate to punish with a fine, because the predictability is important, particularly in a quasi-criminal context. But competition authorities also have other tools. They can impose an order to change, to stop certain behavior, or to do something, which has a different connotation. It's not a criminal sanction. Second, it's important to realize there are also clear cases of abusive conduct. We had an excessive pricing case where the court in Rotterdam literally said that this was a textbook example of an excessive price. So apparently, even for the courts, there can be clear and known examples of abusive conduct. Second, it's important to realize that independent judges make judgment calls all the time about fairness. This is part of our legal discourse. I'm a civil judge myself, and also in a court, I don't do competition cases. I make judgments in a panel about the fairness of a particular situation. And there is no reason why independent authorities would not be able to make judgment calls about fairness. And finally, you know, there is the criticism that fairness is vague, and you know, what is it exactly, and how can you measure it? The underlying assumption is that, well, if it's exclusionary conduct, it is predictable and clear and not context specific, which is obviously nonsense. We all know that if there is exclusionary conduct, it's also not always clear in advance. It's not always predictable. It is definitely context specific. So this is why I see, and I see this if I look around to what my colleagues are doing, is I see a rise in exploitative cases coming up, embracing the normative element that is in fairness, and there's nothing wrong with that. There's also nothing wrong with that because it has been part of our laws since 1958. And whether you like it or not, it is in the law. And yes, after the 70s and 80s, it became underdeveloped and underappreciated and under-enforced and unloved. But that has to do with policy setting, with priority setting, and times have changed. And therefore, we need to move on, particularly in the digital area, where we see that there are entrenched dominant positions. There is moat building around ecosystems. There is vendor lock-in. And there is friction for customers switching. And under those circumstances, it is completely justified not only to use the sword, but also to use the shield. And only trying to reintroduce competition in these markets is I must say, is a bit naive and is waiting for when pigs are going to fly. And as we all know, they aren't. So when we are going to see more exploitative cases, particularly in areas where restoring competition is not feasible in practice and in a timely and effective manner. So I understand the controversy, and among many economists and some lawyers, but it is the law, and independent enforcement agency also have a duty to enforce a law that is in the books. In fact, not enforcing these competition rules in the way it was meant to be would be anti-democratic, and we risk losing our democratic legitimacy if we fail to do so. Let me have a kind of a final word, is that also referring to what Mark van der Woude was saying in the previous panel. In the early 90s, I was a young lawyer, and I embraced the more economic approach. And together with some others, at the time young lawyers in the room, we all decided that we had to get more and better acquainted with IO economic theories. We set up meetings with economists and learned their trade and their thinking. And perhaps now it is the time that IO economists start studying legal theories on fairness and equity, because like a few decades ago, it was for lawyers the right thing to do to learn about economic theories. Now it is the right thing to do for economists to learn about legal theories. Thank you very much.
So, Pinar, the floor is yours.
Thank you, Michael, and many thanks to CRA for the invitation. Just a quick correction. I still serve at the Competition Appeal Tribunal because I don't want some people to start panicking thinking I have stepped down, but I'm speaking in personal capacity only today. So there's no question that a certain concept of fairness exists in the treaty and in the prohibition of Article 102. But of course, the treaty does not define what fair or unfair means, because it merely prohibits certain types of listed unfair practices, such as unfair prices and unfair trading conditions. If you look at the case law, on this, the case law is not that much more helpful in providing a principled framework for assessing unfairness under Article 102, because the concept has not occupied the EU courts to any significant extent so far, and where it has occupied the courts haven't offered a framework that could be applicable across different types of cases and different types of abusive practices. So I think the first problem I have with the concept of unfairness or fairness is an obvious one, and I think this is a real question. What does fair or unfair actually mean? The second problem is that this question immediately begs a second question, which is fairness towards whom? So is it fairness towards competitors, fairness towards customers, fairness towards consumers? So from whose perspective are we to assess the fairness or unfairness of a given practice? Because if the answer is that it could be all of the above, then there's a problem, since the interests of consumers, customers, and competitors are not always going to be aligned, and conduct that's fair to consumers may not be fair to intermediate customers or to competitors of the same firm. And I think anyone with children in the family will know that what is fair to one child is definitely almost always not fair to the other. So if we think of fairness as an objective then to govern abuse, it could govern both exclusionary and exploitative abuse. But I think in the context of exclusionary abuses in particular, and especially again in the context of unfair conduct to competitors, that doesn't necessarily mean anti-competitive in the sense that I think most of us would understand that term as competition specialists. So if fairness becomes an operative principle in the exclusionary conduct context specifically, I think there's a chance that the distinction between competition law and unfair competition law may eventually disintegrate. And we know, even from the EU case law, that unfair competition laws themselves can be anti-competitive because they purposely protect competitors and not competition. Second, we run into the issue of fairness potentially conflicting with welfare as another potential goal of competition law. And that's because a practice that's unfair may or may not have effects on consumer welfare. And where it does not, assuming that consumer welfare is still the objective of the competition rules, then there would be an obvious tension between these two goals. And incidentally, I wrote an entire PhD thesis on that tension about 20 years ago, at a time when even my supervisors thought I was mad because I was looking at exploitative abuse and fairness when all the action was taking place in exclusionary abuse. So in that sense, I'm glad that my time has finally come. Third, fairness can become a means through which parties use competition law to remedy problems that are in essence, and perhaps more correctly, problems of contract law or consumer law rather than competition law. And this can happen particularly in cases alleging, for example, unfair trading conditions, which almost always appears in contractual relations, where one party will have used their power over the other party to extract terms that are more favorable to themselves. Sometimes these can be competition problems, but other times they may not be competition law problems. I think on that note, of course, we should also mention that there's no doubt Article 102 prohibits exploitative abuse. This is why I did my PhD on that. In fact, in some languages of the treaty, it only prohibits exploitative abuse. The difficulty there is that exploitative abuse as a concept runs into similar challenges as fairness, because what does exploitation mean, and under what circumstances does it specify a competition law problem as opposed to, again, a contract law problem or a consumer law problem. So in my monograph from over a decade ago now, I argued that for there to be an abuse, in all abuse cases, you should have both exploitation but also exclusion. So they should both be there. And only then you have a competition law problem. Going forward, I would assume we're going to see more and more cases of unfairness as the theory of harm, especially in digital platforms context. And of course, I wrote these notes before we heard about the Google case this morning. And fairness is an explicit objective of the Digital Markets Act. To my mind, under competition law, fairness on its own cannot be a theory of harm because it's vague and subjective, and there will be significant difficulties in trying to operationalize it in practice, and there will be issues with legal certainty. However, where fairness is essentially a component of an exploitative abuse, and it's possible to identify some harm to competition in such a case, then fairness can play a role and should play a role because it is in the provision, and that would be the role I think the treaty has given itself to play. So I think the Apple-Spotify case could have been a test case, actually, to see whether this type of unified approach to abuse could work. The Commission has, of course, chosen to run that case only as an exploitative case, but based on the information sort of in the public domain, I think it would have been possible probably to run that as a case that covered both exploitation and exclusion. Thank you.
Thank you very much. A quick observation on that, from quick comment, and then we'll move on to another controversial topic, which is that from an economic perspective, we know that you can have, of course, consumer harm without market power, without dominance. If you look at what the CMA also is doing, and with consumer protection directly focused, we know if you look at the literature of drip pricing and things like that, I mean, you don't necessarily need market power. And then one question, I don't know, maybe someone will want to comment on that, but I was wondering, what is the relevance of dominance then? And is it more of a materiality threshold? I mean, maybe it's a legal question, so that's why I'm putting it out there, but it feels a bit different because you don't need market power to implement some practices, so then is it relevant under 102 or not? I don't know, and comment on that. But let's move on to the next controversial topic. Yes, no. Yes, and please comment, because I'm going to stay with you with another one, but let's try and keep it a bit briefer, if possible, so that then we can cover also the other topics, but it's tying. So my questions on tying is, Okay, looking at the guidelines, there was a presumption which was not fully understood, I think. And okay, when does the presumption come to play regarding tying? And the guidelines, do they follow the previous case law? And how do you expect the role of tying to evolve in the future? So let's do it the other way around. Yeah, a bit more brief if possible, but Pinar, starting with you.
Yeah, thank you. So according to draft guidelines, tying and bundling fall outside competition on the merits. That's paragraph 53. And falling outside competition on the merits is one of the two limbs of abuse. The second limb is the capability to produce exclusionary effects. And then the draft guidelines say, and I quote, certain forms of tying are presumed to lead to exclusionary effects. So in some instances of tying, it's possible that both of the two limbs of the test of abuse are ticked. So a presumption can exist according to the draft, depending on the specific characteristics of the markets and the products at hand. And then there's a footnote in the draft which provides an explanation of the circumstances in which a presumption will operate, so trying to elaborate on those market specifics and product specifics. So if, according to the footnote, in certain circumstances, the anti-competitive or exclusionary effects of tying and bundling can be presumed. And I'm going to quote what the footnote says, because I can't paraphrase it, because I don't quite understand it. So I quote, so effects can be presumed in situations where the inability of competitors to enter or expand their presence in the tied market is likely to directly result from the tying conduct due to the absence of clearly identifiable factors that could offset the exclusionary effects. So I'm afraid I can't really answer your question to explain under what circumstances the presumption will kick in, because the information in this statement to me seems not necessarily fully capable of sort of distinguishing tying that can be presumed to generate exclusionary effects from tying that cannot be presumed to generate such effects. But I mean, the question I can more easily answer is whether the draft follows the previous case law on tying. I think in that regard, it's quite clear that the guidance adopts a more formalistic approach to the practice, whereas the case law is not so formalistic. For example, neither the Microsoft Windows Media Player decision nor the Google Android ruling adopts presumptions for tying. In fact, the Commission's own assessment in both of these cases actually involved an assessment of effects. And I'm not an economist, but I had the privilege of recently publishing a paper on the draft guidelines with two brilliant economists, and a paper we discussed last year actually, Massimo Motta and Chiara Fumagalli, and I understand that from an economics perspective as well, tying is a practice that is likely to generate pro-competitive effects. So in that paper on the draft guidelines, we had recommended that tying be taken out of the presumptively abusive practices category going forward. I think it's going to become increasingly more important, tying. It's probably going to be the abuse we're going to hear most about, alongside perhaps unfair trading conditions. And therefore, how the approach to tying evolves is going to matter a lot, because it raises, after Microsoft once again, the questions of what the limits of competitive product design are as distinguished from anti-competitive tying, especially in digital markets where almost all of these digital services and products operate in ecosystems. So questions such as what is a product versus what's a feature, how do consumers use these products and services, what are the search or switching costs, value of convenience, these have all become relevant once again, and perhaps they're now more difficult to answer than in the time of Microsoft, because we now have ecosystems, as I said, across so many of these products and services, and neither consumer habits nor internet penetration or internet availability look anything like they did in 2004.
Thank you very much. And I feel, if you don't mind, Martin, I feel I need to give the floor to Lindsay first, as we've been discussing the guidelines, and then if you want to come back and react.
Because I'm very happy to provide a little bit of clarification. I mean, what the guidelines we're trying to capture is, of course, the case law that relates to traditional industrial goods. It's Hilti, it's Tetra Pak, it's I have a nail cartridge, and I have a nail gun, and I have nail cartridges. How am I going to counter that tie? We have heard that there is pushback to the existence of a presumption even for industrial goods. That's something that we're thinking about. We'll see what the court has to say in Android, because of course I'm sure you've all read the opinion of Advocate General Cocotte, who does say there is a presumption for certain terms of tying in terms of likely harmful effect, so we'll see. But the good news is we're talking about digital cases, and that paragraph of the guidelines never applied to digital cases, and all of the tying cases that the Commission has ever run, as Pinar has pointed out, have effects assessment. So I think it's incontrovertibly true that in digital markets there can be real consumer value brought about by the integration of goods. I think it's also true that there can be harm brought about by tying, and I think what antitrust law is there for is to do the full assessment to distinguish those two categories. So I think it's difficult, in fact impossible, to have a prior on the likely impact of a tie in a digital market. Question mark still open if you're talking about ties in industrial goods. Another reason to wait with bated breath for the Android judgment.
Thank you very much. Martijn?
Yeah, so I have to kind of collect the thoughts a little bit. Maybe one aspect also to bring the topic back to exploitative conduct, which is important to realize, and I'm curious how the case law will develop, is that tying can of course also be an unfair condition. In our Apple case, we put forward the theory that discrimination as an unfair condition, well, tying, I think similarly, can also, depending on the circumstances and the facts of the case, can also be an unfair trading condition. Coming back to your question about, yeah, but basically if I paraphrase it, is, well, what you're saying, doesn't it apply to all companies? Or isn't it part of consumer protection? And there I would say no, because in the treaty, very clearly, there is a distinct regime for companies with a dominant position. It's established by the court, they have a special responsibility. It is acknowledged that not all the rules, all the competition rules apply equally to all the companies. There is a subset of companies, dominant companies, for which a special regime is applicable. And that is indeed in the law.
So that is where economists need to study the law again. So circling back to this. All right, very good. Now let's move to Michael. And okay, if you take a series of ties, and actually the word has been mentioned already, you probably get an ecosystem. I don't know, and I don't even want to try and define what an ecosystem is, and I'm going to leave the semantics aside. But a couple of questions for you, Michael. So, you know, given your research on this topic, what is sort of your insight from the business angle? And you spend also a lot of time with entrepreneurs. How do you think about dominance and contestability from that perspective? And last one will be on AI. I mean, I know you've been sort of losing sleep over AI, thinking about AI almost, right? So what is the impact of AI on competition, and is it making market more contestable? You know, there's the idea that there is competition, there is a consensus, there is competition on AI, but at the same time there are concerns. And yes, let's try and unpack all this for us, please.
Well, if you want a full answer to that, the answer is 42. So those of you who have read The Hitchhiker's Guide to the Galaxy know exactly what I mean. Let me try to take a few of these things and see whether we can make sense of them. First of all, why bother with ecosystems to begin with? Partly to answer your question of what power are we speaking about? What the heck is ecosystem power? Where do you see it? Well, partly you could say you see it in market capitalization. You just take the top companies in terms of all the wonderful pension fund growth that we've seen. They are companies that run these ecosystems. But more than that, just to give you a sense of how people, not only on the small side, but on the large side, see them. I moonlight as an academic advisor to BCG's Henderson Institute, so we've got a bunch of juniors who can go and do nice NLP through all the reports. We looked at the incidence of the word ecosystem in all the large company reports between 2008 and 2017. They grew 13-fold. What the heck does that mean? There's a paper that I wrote that ended up sort of defining it, but it started its life as a gripe of a guy who is a strategy guy looking at value migration, trying to figure out what on earth is it. And I admit that the more we started looking at it, we realized that there are a few things that actually make sense. And articulating the underlying economic relationships can help you understand both what drives value for you as a business user, but also where the problems emerge if you want to think about it from a regulator. And the answer there is that it is a group-level, non-generic complementarity, which sounds entirely simple and trivial. But in a way, in the same way that Ollie Williamson's aha that asset co-specialization leads to a web of fairly predictable and understandable and studyable implications that have both strategy and competitive implications, I think that the articulation of the understanding of what the heck these interdependencies are start opening that up. And if you want to think about this as a field of study, right now we had one of these sort of field of strategy, and I think that in the survey of academics in the field, ecosystems was the sort of biggest topic in terms of the new areas of interest. That hasn't stopped the IO economists saying that there is no research yet and we don't know it. Basically what it says is that we don't read outside our field. I think Melissa Schilling is in the audience. She'll speak in the next session. There's a fun paper saying all the fields in terms of different parts of management and strategy start citing each other other than the economists. They don't like citing anyone other than myself. Sorry, Fiona. There is actual work, there is empirical work. It is not necessarily noticed simply because of the rather peculiar institutional construction of particular fields and also the cottage industries in terms of the way that we analyze the world. One of the problems is that this may need you to rethink whether market definition is a problem to begin with. And what I think that we're seeing is that we're stretching the boundaries of market definition to define things that are not really market, where the problem does not really exist in market. The problem exists in terms of ecosystems. What do we mean? Two things. The first thing is the multi-product ecosystems. Simple stuff, economically, a supermodularity. Value of A increases in the value of B, in the presence of B. My iPhone is more valuable if I have an iWatch and vice versa. That's why you see these companies creating these lovely webs of products because they feel that they will be able to add value. The problem is we also have multi-actor ecosystems whereby you have complementers that are being drafted in order to support it. Alleviates the pressure in terms of assets, users, other people's energy. It's dandy nice if you can have it. And by the way, if you create a nice bundle that you can crack the whip and people have to go there because they don't have any other choice, well, you're kind of stuck. And that's where the problem starts beginning, because you're like, oh, if I start looking at these ecosystems and if I explicitly define them, perhaps we're going to go somewhere. And I commend the Commission. I think that the Booking.com Eater Valley case is the first case where they did dare to put ecosystems. Marcus, I think that the CMA went close in during your tenure with the initial effort in the articulation of the faults in terms of the well-known case of Microsoft and Activision, but I think the ecosystem logic went back because the lawyer said, you're not going to be arguing this in court. Ecosystem is rubbish. How the heck are you going to look at the specifics? And it is true that the specifics are currently being defined, but I think that doesn't mean that we cannot look at it seriously. Neither does it mean that we can take other things that are not made for that, do not describe the empirical reality and what people in the field will tell you ecosystems look like and where the problems lie. Now, consider why understanding ecosystems and the nature of our ecosystems is a problem. And I'll give you sort of one simple typified example and consider iOS and Android, two big ecosystems. You're like, ooh, is there competition? Is it going to be socially efficient? And on the other hand, Uber and Lyft. You could say, two here, two there. Yes, but if you think about the Android iOS, because we have one phone, essentially the market is captive. Even if Apple has 7%, I don't care that it's 7%, I don't care that it's not dominant. My wife has an iPhone, I have an Android, she is in the iPhone church. I cannot get her out, and I will actually not jump to iPhones. What does that mean? Take a big firm with network externalities, right? Take Match.com with Tinder. Nice booking, nice dating site, and then you're like, well, if I really don't like Apple, I'm simply going to walk away. what happens? You lose all of the market, and you lose the market of the 7% simply because people are not going to be dating on their computers. They're going to be swiping right and left on their phones. Even worse, are you going to tell your Android people that they're going to be dating, other than the people who have iPhones, the other cuties? You want to date them. As a result, you are now stuck in your core market as well. So network externalities work as a problem. Would you see it in the current definitions? You wouldn't. If you start looking at the ecosystem structure, would you start seeing it? Perhaps you would. The underlying economics are a function of the way that strategically these things are put together. And then you can start saying, can I start pushing them on the types of practices that exist, whether it's interoperability, as I know you've been pushing about, or other practices that may end up having something. People will jump up and down saying, ooh, interoperability, that's going to be unsafe. Yeah, right, well, it's unsafe because you can then pretend that it's bloody murder and you can continue dominance, thank you very much. And then you start going into the, well, are we taking these things seriously? Or are we going to accept that perhaps according to the people putting them together, there's going to be some push. Final thing in terms of AI. People are saying, oh, look, AI is wonderful. It's going to take care of all of these problems. Don't you worry. And it is true that some of the innovations from AI are coming from different quarters. Now, of course, there's the issue, the CMA had a nice little map in the, well, are we really speaking about some gentle tying, or are we really speaking about mergers and all by name in terms of the alliances that start existing throughout the sphere? But here's the problem. The problem that I see with AI is that AI is currently in its, I'm only nice and sweet because I'm starting. All the big technology companies are making massive capital expenditure spends. I spend my time working with people in private equity shops and on boards and on people in less small companies, but more bigger companies, trying to figure out what the heck does it mean for retail? What does that mean for FMCGs? What does it mean? Because essentially what you have is a technology that can direct you much more than Google can. And as a result, it has the potential of transforming the way that we consume activities. It has the potential of creating a squeeze that will make today's profits from companies that say tech, but essentially are not tech. Google is 70% media. It is not tech. It uses tech to absorb the media profits. Same thing is going to happen in a swathe of sectors. And even if you say that there is a potential contestability now, the existing firms are going to jump, and just wait you see what Google is going to do and what all the other big tech companies are doing. But even if it doesn't, it means that the problems that we had with ecosystems are going to be amplified. We have not dared addressing the real problem by putting plasters and stickers on a problem, pretending it doesn't exist, thinking that just the market definition or a few timid uses of ecosystem will do. It is no longer relevant. The people that I work with see the problem. It is time people in antitrust starting seeing the problem.
Thank you, Michael. Indeed, that was very good. So Leo, you've been waiting patiently. So I have a couple of interrelated questions for you. So first, probably you will want to say a few words and react to what Michael just said. And then interested in particular, about a case so in the US, the FTC judgment, the Meta judgment, that was won by Meta over market definition. And I know that you've been doing a lot of research in particular that is relevant to this case on network effects, how people switch or don't switch, and how they use social platforms. And the last question is, how do you generate, I think that's really interesting as well, is how do you generate evidence, right? It's not just a theory, but you have this way of thinking, okay, I need an answer, I need data, and you're generating evidence, and you can tell us more about that.
So first, thanks for having me. It's been a pleasure. Starting using the discussion on ecosystems to transition into the second part of the question. I think when we're thinking about ecosystems, we're thinking about the convenience is given to consumers against a lock-in, potential lock-in, right? And one way to think about this is that we've been developing is this series of papers around the idea of non-user utility, right? When you think about an ecosystem, how much of it is actually increasing the utility of those that are in the ecosystem versus just making it really costly to be out of the ecosystem, right? And that's something that if you use the right methods, the right approaches, you can actually assess for a given case, right? And sometimes seemingly innocuous integrations or tie-ins can actually be operating through the non-user side in terms of cost. For example, you think about the push that Instagram has made for DMs, direct messaging, texting within Instagram, integrating into the whole Meta messaging ecosystem. Yes, it makes Instagram more convenient, more practical. You can text within Instagram. However, you also make it very costly to be out of Instagram. Suppose you're someone who really don't want to deal with Instagram, like all the toxicity. You don't want to be watching influencers' lives. If your friends are on Instagram, now it's become really costly because you're texting on Instagram. So that's actually how much is creating utility to those who are inside Instagram versus making it very hard to be out of Instagram. It's something we've been measuring. For example, another case, when you think about, it was mentioned iOS and Android, like the issue of like the green bubbles, blue bubbles. And we find across a series of experiments that green bubbles make it really costly for you to, leaving aside the different operability issues, the adoption of the same communication standard now that has removed that, Apple has kept the green bubbles, right? Why? Well, what we show is that it's actually creating a lot of costs, a stigma cost to Android users, especially in the US, who are recognized as being lower income. The inference that people make about Android user when you see a green bubble is that they're less attractive as well, actually speaking of dating markets. So even iPhone users, to a large extent, would like to get rid of the green bubbles, right? Yet they're stuck. They're trapped by that feature. So it's one example of that. And this is particularly relevant when you think about networks, network effects. And we've been doing a lot of research around that. Think about a network as a, or social media platform. In the beginning, as the network grows, the product becomes better for those who are inside the network. You're not going to do much if you're the only person on a social network, right? So it goes bigger, the utility of being inside goes up. But at some point, when the network becomes so big, perhaps too big, it becomes very hard to be the one outside of the network. You're going to be socially excluded. You're not going to know what's going on. So the question we start asking is, like, to what extent are people joining these networks, not because they like the network, but because they dislike it less than being the one outside of the network, right? And that's it. We've done a series of papers about this. One just came out this month in the American Economic Review, where we tried to consider this idea of product market traps and study this in the context of social media. We starting with simple survey evidence. What we find is, like, if you ask Instagram users, young Instagram users, okay, college students, would you prefer to be in a world where Instagram exists or doesn't exist? We find that about 50% of Instagram users wish Instagram did not exist, right? And they're still using Instagram, right? Similar for TikTok. So it starts building the case that perhaps, just because people are using these products, it doesn't mean that they derive benefit from these products. It could be that just using this product is less bad than being the one out of the network, right? So we try to move forward and try to actually elicit, make claims about welfare and prices associated with that. So we use the standard techniques of eliciting how much do I have to pay someone to stop using TikTok or Instagram for 1 month. And in fact, you have to pay people quite a bit of money, about $50, if you think about college students. So typically, people would stop there and say, and it has been done across cases and discussions, like, okay, if you have to pay someone $50 to stop using TikTok, it creates a lot of welfare. You have to pay someone $50 to stop using it. Well, it turns out the same person who's willing, you have to pay $50 to stop using TikTok, is willing to pay $30 to get rid of TikTok, right? So now, it's important to consider the right outside option when we think about welfare. We typically think about the case in which the product still exists, but you're the one removed from the network. Of course, it's going to be costly, but the right outside option is, what if the product didn't exist? What if the network didn't exist, right? And that's how I think we should be calculating welfare in these cases. So it's important to have the right measurements, and we have the right tools now with these experiments. And why is it the case, getting to your FTC question, why is it the case that these numbers come out so differently? Yes, well, it's because what you do with your time, if you stop using a social media platform alone, is very different than if you stop using together with others, right? In fact, when we ran the experiments, we found that if you get someone to stop using, in the anticipation of the TikTok ban that didn't happen, but there was a moment where there was a possibility that this was going to happen. So we considered different scenarios, and we show that what people were about to switch in terms of time use when they expected a collective ban of TikTok was very different than if you pay someone to stop using TikTok individually. Well, it's kind of obvious if you think about it, right? These social platforms are social, right? So if you stop using these products alone, and everyone's still using them, you can't do social stuff with them because they're still on the platform. So you substitute toward a bunch of activities that are not social. You read more books, you go on hikes, you do things like that. But if you get people to deactivate together, they're much more likely to switch to another platform. So that really matters for the definition of the market. So in our experiment, when you run the right approach, right experiments of collective deactivation, we find much narrower definition of markets for social media platforms because they're much more likely to substitute toward other social platforms. So I think it's very important to consider the opportunity to run different types of experiments. Now we have the tools, and then this could be very, very helpful for these types of discussion.
Thank you, Leo. So, Michael, I don't know if you want to say a few words, and otherwise I have a question to Lindsay and you, Martijn, is whether this lab experiment or innovative way of generating evidence, is it something that you would consider in your own cases, and in what context, in one or two, in other cases, in terms of more DMA or regulation? So, yeah.
The answer is self-evident, yes, and I think that it makes a heck of a lot of sense. And that tells you also the problem of framing. A moment ago I was telling you that the fact that we refuse to look at an empirical reality, that whether you work with technology companies and with the executives of technology companies, or you work with the entrepreneurs, will describe it in exactly these terms, will tell you how the ecosystems are structured, will tell you what the squeeze points are, and we can't even speak about them. We can't speak about them at two levels. At the level of the individual offering, which is what Leonardo was saying, and here the problem, which is similar to the examples that I was giving with the Android and iPhone. By the way, you don't have the same problems with Uber and Lyft, and you don't have them because you can shift to both of them on both sides. Coincidentally, that is why both Uber, following Grab, and Gojek in Southeast Asia are trying to expand their offering to create something that makes it hard to get out, where the price that Leonardo was saying would be difficult because they bundle payments, they bundle transport, and they try to say, how can I expand it in order to lock you in and make you hate me but still stick with me? So I think that these are things that we can articulate and then measure. Need to articulate first, articulate at the level of the individual and the level of the offering, and measure. But I think that both are doable, and I think we should start doing them.
And a quick comment on that before turning to you, Lindsay and Martijn, is, the way I see it is, what is very difficult, right, is you're talking about something that at the same time is creating value. That's what you say, and it's like too good, in a sense, and then that it can harm in certain circumstances. So I think the point about you need data, and of course, that's what I'm going to say as economist, but it's interesting, like both perspectives are valid, but how do you measure this? How do you disentangle between the two? Because it is indeed counterintuitive at first sight that you're creating a lot of value so that people don't switch, but because there is value. So when is it becoming a problem, and also when is it relevant under 102? So. Lindsay?
There would be a lot to say. There would be a lot to say. But if I restrict myself, I can't stop myself mentioning the fact that our market definition in our Meta case is obviously not the same as the FTC's. It's not the same type of case. But I think also we put to one side Meta's arguments in terms of the natural experiment in India precisely for the reasons we allowed in the market definition notice, that we didn't think it was a good indicator of user substitution patterns. We don't have a hierarchy of evidence, of course, in terms of what we look at, but we are blessed in the digital sphere by many companies that run big experiments all the time, and those are often super valuable sources of evidence for us. In that Meta case, in fact, the big experiments that some of Meta's competitors had been running in terms of closeness of competition were super useful. And of course, in quite a lot of our work, we've also been able to rely on active complainants who have their own networks, where they can also do big live experiments. That was the case in our Apple Music streaming with Spotify with a big Android experiment. Consumer surveys, super useful. But my favorite behavioral experiment remains the experiment that Bing ran in the course of the Google Shopping case, where we substituted the first and the 10th ranking on a Google search page to see how users reacted. And what you saw was that placement was everything. There was absolutely no difference also in terms of clickback, in terms of the content of a site placed at place 1 or place 10. You could reverse them and people would still be happy with what they were given in place 1 on a Google search site. And that for me is still the nicest behavioral experiment that we run. And thanks to Microsoft for making it possible.
It's very interesting, and I think it would be interesting to see how this discussion about what is actually value, how that will develop over the next years. And I wouldn't be surprised that in maybe 10 years from now we also change our perspective on what value is. And I think we've now starting to move also within the agency with discussions about welfare. Is it perhaps well-being? What are negative externalities of the work that we do for the rest of society? What is the negative externality of addictive designs, of addictive algorithms in social media? And bear in mind that, of course, we looked at this from a broad perspective. We are not only a competition authority, but also a consumer protection agency. So I see that. And we take this discussion also in the context of what I discussed earlier, of what is fair. So there is a moving debate. I do not have all the answers, but it is definitely being researched. We have a group of behavioral psychologists, about 20 people in our agency that run experiments, often experiments by ourselves, sometimes with companies. But we do more and more research in this area because we believe that needs to be further explored because this is the next territory in society. I think what you said was so right, is that we have to think about the new dilemmas in our societies with the effects of these big digital ecosystems, and we cannot close our eyes for these negative effects.
Pinar, do you have any observation on what was just discussed, or otherwise I have one last question for all speakers. Okay, so I think there is one theme that we need to talk about, which is remedies. Right? I think, as we know, remedies have been largely inefficient, let's say. So I think the question is it that we pursue the wrong cases, or is it that the remedies were not sufficient? I mean, what is going on? But there is, I think it's fair to say, a bit of a consensus that it was not sufficient. Potentially, I mean, it's part of the motivation for the DMA. And two examples to set the scene. So there is a judgment in Berlin court, I think in shopping, saying that 8 years after the decision, well, actually remedies were not really efficient and were more cosmetic than structural. So that's on the one hand. And on the other hand, if you look at Google search in the US, it's very interesting, I think, because you have a very strong judgment on the infringement. But when it goes to remedies, Judge Mehta said that, I mean, the remedies are relatively weak, say, relative to what was asked. And part of the reasoning is, well, AI is a game changer. So, you have really this thing that, well, conduct is past-looking. You look at the past to assess the conduct, but remedies, in a sense, are forward-looking. So conceptually, it makes sense to have a difference between the two because, well, one is backward-looking and the other one is forward-looking. And if things have changed, which potentially was the case, or there was a certainty according to the judge in the US DOJ case, then we may not need to do anything, which I think is interesting because by the time you can do something, you don't need to do anything, although you should have done something before. So what's, yes, well, take it away and go, how do we design effective remedies? And of course, the further background is, we have Google AdTech, where structural remedies are being discussed. And then we also have AI, which could be a way of challenging. We are seeing cases in AI space, but the cases are different, I think, from the question of knowing whether AI can sort of disrupt the dominant positions, right? What we are seeing is firms are using their assets to favor potentially, or this is a claim, or what is alleged, some services. That makes sense because AI is developing, but it's different from the question of knowing whether the positions are being challenged in the first place by this new wave of technology. So, I don't know, Lindsay, do you have any comment on that, or but interested in everyone's
Sure.
views
I mean, I think
in a few minutes?
You know, I don't want to come over as all kind of glass half full, but I don't know if the picture is quite so gloomy in terms of what we've learned in terms of remedies and tech cases. And certainly if I come back to tying, I think it's certainly the case that our first Microsoft tying remedy was an absolute failure. If you look at the progression through choice screens, through the types of remedies you see in Microsoft Teams with an interoperability requirement, with data portability, with a price delta, I think there's some learning by doing. And certainly for us, the Expo study we just ran on our antitrust remedies has been a helpful indicator for the future. Specifically, what we are looking to change, which doesn't require changes to Reg 1, is taking a more collaborative approach to remedies once we've found liability. So that's why you see, for example, in AdTech, that's public record that we are out in the market currently market testing the remedy that Google has proposed. I think bringing on board all the ideas to think about the remedy makes a lot of sense. And that idea of a liability and a remedy as distinct phases, maybe that's something we'll want to do more of in future. I think one of the big challenges for us in digital in terms of remedies is resetting markets, right? It's thinking about if a market is tipped. It's the UFEX type of jurisprudence that says if you want to bring an infringement effectively to an end, it's not enough just to stop the conduct or to just deal with the market as it exists after the abuse. But those are complicated issues of counterfactual, those are complicated issues of quantification, but that's a piece that we're certainly looking into. And then I can say very quickly, you know, obviously on the structural behavioral piece, we have a hierarchy in Regulation 1 currently. Before we can impose a structural remedy, we are obliged by law to demonstrate that there is no behavioral remedy that would be sufficient, and that's a really high barrier. It's not a hierarchy that exists in many member state procedural systems in antitrust. We'll see where things land on AdTech. That is still something that we're looking into. But on the Reg 1 piece, if I look at our antitrust procedures, and if I think about digital markets specifically, I think you can really ask yourself if that hierarchy of behavioral structural remedies really makes sense.
If I could continue on the at least glass half full area with Yannis Lianos, who used to chair the Hellenic Competition Commission. We co-edited a special issue on industrial corporate change, and we looked at the evolution of regulation and ecosystems. And I guess the point that we're making there, that I would reiterate here, is that if you think about antitrust has expanded in order to essentially catch up with the realities. From the Polaroid case and the idea of aftermarket to the multi-sided markets and Amex, essentially our understanding is lagging but still matching empirical reality. I am concerned that the current spin, not entirely random and clearly motivated by the funding that exists in Drove in order to give the rhetoric, means that the understanding and approach of ecosystems, both at the level of the specific problems in terms of the markets, what are the right counterfactuals, what Leonardo is pointing out, as well as what is the business logic of these groups, and as such, when are we concerned and when are we not, which are the sort of bigger and latent issues, are not yet addressed. But we have seen them addressed in the past, which means that we are capable of including them more explicitly in our reasoning and in our analysis. I finally think that some procedural stuff, like what the DMU says it can do, has not really affected getting some greater, I mean, we'll see given the politics there, whether they feel entitled to do any changes, slightly different story. Goes into the geopolitics, which is another complicating factor if we had another session of an hour and a half, which drives the possibility of having things in terms of how are you allowed to either treat your complementers, and in terms of AI, what are you allowed to do with the data? People hate GDPR and the AI Act, but the question of where are you allowed to operate in data, super important. I think that we need to look at it more carefully.
I know we're running out of time, so from the economics academic perspective, I think our duty, really, our goal should be to generate the right evidence to generate the right diagnostic, to generate the right remedy, right? And I think there are a lot of tools that we're starting to use more in economics that allow us, for example, as I said, experiments allow us to unpack things I normally couldn't unpack. For example, if you just look at choice data, you can't tell if someone's buying a product, thinking about this issue of like, how much of it is the value of the product versus avoiding the cost of not having the product. If you just look at choice data, you just see the bundle. You cannot tell how much is driven by the first versus the latter. And that's the type of stuff you can do with experiments. So I'm seeing more and more academics using these types of tools, including in IO, we're seeing a lot of these methods being used. So I think we're going to be able to have this interplay between like the evidence we're generating and informing policymakers.
I know we have 2 minutes, and we could be the first panel to finish on time, so I will be really quick. I think there are two, from an academic point of view, there are two major challenges in relation to remedies. The first one is that we don't have a theory of remedies, either in law or as far as I'm aware, or in economics. And then we don't really have empirical data. So it was really welcome that the commissioned that study on remedies, but we would need, I think, a lot more of those. In fact, we need studies which look at actual markets where competition intervention took place and remedies were imposed, and try to sort of reverse engineer from the outcomes in those markets what may have worked and what may not have. Those are obviously very difficult studies to conduct. They're very expensive to run, but I think this is an obvious area for more researchers to get involved and for more public and even private funding to be invested in, just to find out why some remedies work and why some don't. At the moment, we just don't have enough data or a theory.
Yeah, so building up on Pinar's remark, is I think, first of all, in appropriate remedy design, market testing is obviously crucial, but we cannot stop market testing with, the parties themselves, with competitors and their view. It should be broader, and therefore the input from independent experts and academia is extremely important in designing the remedies. And then thirdly, empirical A/B testing. I think particularly when it comes to digital cases, we have the capability, or the parties can have the capability, and we can control that, to do empirical A/B testing to see what actually works. The downside is, with many of these remedies, we can only tell after a while whether it has worked. And therefore, the thought has come up in our agency, just as an experimental thought, is that maybe we should put sort of crown jewel provisions in our remedy design, like we have in merger cases, where, the parties offer to sell an asset, but if they can't, they have to sell their crown jewel. Maybe we can do that also in remedy design in conduct cases to see. It's an experiment. We haven't tried it and tested yet, but it is something that we are considering.
Thank you very much. So please join me in thanking the fantastic panel. Thank you very much. Thank you.